Hello, welcome to Universalism Cultural on Human Rights and Duties. I am Vidya-mitra Ahmed. I'm an adjunct faculty at O.P. Jindal Global University. What are the learning outcomes of the course? In the international human rights discourse, what is meant by universality? We'll also look at what's meant by cultural relativism. How does cultural relativism pose a challenge to the universality of human rights? We often hear terms like universal remote or universal adapter and the like. The universal nature of the device implies that it will work anywhere in the world, regardless of local differences or variations, if any. Likewise, in the context of human rights discourse, this term universality is often used. When we assert that a list of rights are universal, it means that whether a person is staying in Bangladesh or Burkina Faso, or living in a country in the global north or south, shall equally enjoy these rights. The universality also means that all persons shall enjoy these rights regardless of distinctions based on sex, religion, race, color, etc. Are human rights everywhere the same, or are they relative to culture or time? The moment we move from one culture to another, are there new and distinct set of rights? This module seeks to understand universality and challenges posed to universality by various critiques. What is meant by universality in the international human rights discourse? Jack Donnelly lists three different senses of universality, namely international legal universality, functional universality, and overlapping consensus universality. As human rights have been endorsed by nearly a majority of the states, such acceptance, in his view, gives them international legal universality. This aspect is elaborated further below. The functional universality of human rights is derived from the fact that they are the only proven and effective set of practices to protect individuals, families, and groups from certain standard threats posed to their dignity by various actors. Referring to leading philosophical, ethical traditions and doctrines and their common acceptance of human rights, Donnelly observes that it gives them overlapping consensus universality. We now take up the international legal universality for a detailed review. The United Nations Charter was adopted in 1945. In its preamble, there is a clear reference to the protection of human rights and fundamental freedoms. Article 1 of the UN Charter, which deals with the aims of United Nations, also lists protection of human rights as an important objective. All countries of the world have signed the UN Charter. The Universal Declaration of Human Rights, 1948, has also become a part of customary international law, and it's binding on all countries of the world. It's regarded as a mother document or constitution of the world human rights movement. UDHR is the first such comprehensive listing at the international level of the inalienable rights of all persons and is an outcome of an agreement among nations as to the rights they possess. It represents common vision or shared understanding of the international community of human rights. It's a common standard of achievement for all peoples and all nations and is used as a gauge by which countries, NGOs, and others can measure the observance of human rights by any entity. The facts mentioned above support international legal universality. There is no country in the world which has not signed at least a single core human rights treaty. If one looks at the Convention on the Rights of the Child or the Convention on the Elimination of All Forms of Discrimination Against Women, one finds that virtually all countries of the world, barring a few exceptions, have signed and ratified them. The International Covenant on Civil and Political Rights 1966 and the International Covenant on Economic, Social and Cultural Rights, which are part of the International Bill of Rights, have been signed by nearly 84% of the world's countries as of 1st September 2017. If one takes all 9 core human rights together, they have been ratified by nearly 71% of the world's countries, which is close to 3/4 of the countries in the world. What is cultural relativity? Often certain regimes across the world argue that they will not fulfill some rights on the grounds of cultural differences. When confronted by the international community about human rights violations or questioned about their human rights record, certain countries have in turn questioned the universality of human rights and their applicability uniformly across the world. This has taken a number of different forms. Some took the stand that human rights are a Western construct and Western in substance and import, while countries in Asia or Africa or non-Western societies had different values or understanding of human rights. So let's look at the definition of cultural relativism. In simple terms, the cultural relativism can be defined as a doctrine that holds that at least some cultural difference or variations are exempt from legitimate criticism by outsiders. A doctrine that is strongly supported by notions of communal autonomy and self-determination. Another competing definition of the term has been expressed as follows. Human values, far from being universal, vary a great deal according to different cultural perspectives. Some would apply this relativism to the promotion, protection, interpretation and application of human rights, which could be interpreted differently within different cultural, ethnic and religious traditions. In other words, according to this view, human rights are culturally relative rather than universal. It can be seen from the two definitions that the cultural relativists insist on protecting their cultural practices and insulate them from being subject to Eurocentric evaluative standards. How does cultural relativism pose a challenge to the universality of human rights? There are many practices in the contemporary world which can bring them in direct conflict with the universally recognized human rights. The French law banning the practice of wearing headscarves or other religious symbols in schools was fiercely opposed by Muslims and Sikhs. In the Indian context, minority religious groups have strongly opposed reform of their personal laws on the grounds of maintaining the sanctity of their culture. Female genital mutilation is a serious violation of human rights, but it has been practiced by certain African groups and the Dawoodi Bohra community in India as a cultural practice. Dowry and dowry-related harassment negate women's human rights, but they are rooted in culture. So are notions of ritual, purity, impurity, and so-called upper caste and lower caste, and hierarchical division of society based on castes. The international discourse on human rights has always been marred in the dichotomy between cultural relativism and universalism. While the adoption of UDHR was seen as a major leap for the advocates of a universal approach towards human rights, as it found acceptance by and large from the global community, it has also given rise to resistance from those groups which insist on safeguarding their cultural identity. The concept of cultural relativism has been the major premise for such expressions of protest against the universalist approach. Essentially, the cultural relativists believe in the validity of all cultures and value systems, and consequently argue that universal rights are insensitive towards cultural diversity. So how did cultural relativism evolve historically? So, historical evolution of cultural relativism. The advent of modern values after the European Renaissance had an everlasting impact on the legal systems around the world. With the spread of their colonial power, European thought spread across the world and eventually pushed the advanced conception of human rights. The modern form of cultural relativism has grown as a reaction to the Eurocentric approach towards human rights. The core of the Eurocentric theories is premised on the idea that non-European cultures are primitive and even inferior to the European people in terms of culture or intellect. As a principle, the cultural relativists believe that moral codes and social institutions reflect a vast scope of cultural variability and that such variations should be exempt from the criticisms of outsiders. Therefore, the relativists resist the imposition of European values while deliberating on theories of human rights. So, the first phase. In 1947, a strong opposition was mounted by the American Anthropological Association against the Eurocentric worldview of human rights in its statement to the UN Commission on Human Rights. This was arguably the first instance where the cultural relativists asserted themselves at an international forum where the idea of universally applicable human rights treaty was being contemplated. The statement strongly argued that the Universal Declaration of Human Rights must include cross-cultural philosophical anchoring so as to gain acceptance and be considered as a legally binding document. The relevant part of the statement has been reproduced here. Because of the great numbers of societies that are in intimate contact in the modern world and because of the diversity of their ways of life, the primary task confronting those who would draw up a declaration on the rights of man is thus, in a sense, to resolve the following problem. How can the proposed declaration be applicable to all human beings and not be a statement of rights conceived only in terms of the values prevalent in the countries of Western Europe and America? In effect, the statement argued against a European worldview of the idea of human rights and called the Commission not to give an impression that the philosophical anchoring of the universal values was limited to Europe and North America. Even though cultural relatives argued with much fervor they could not influence in changing the nature or wording of the Universal Declaration of Human Rights in any significant manner. Now let's look at the second phase of evolution of cultural relativism. During 1990s, developing nations of Asia started the second phase of revival of cultural relativism. Most of these nations were under colonial rule while the UDHR was being conceived. By adopting the Bangkok Declaration before the World Conference on Human Rights, the Asian nations, supported by Iran and Cuba, came forward with a strong stand of human rights with the following statement. While human rights are universal in nature, they must be considered in the context of a dynamic and evolving process of international norm setting, bearing in mind the significance of national and regional particularities and various historical, cultural, or religious backgrounds. It's noteworthy that the Bangkok Declaration did not believe that it was possible to come up with a single, distinctive, and uniform human rights theory even for Asia. It acknowledged that Asia in itself is immensely diverse in terms of culture and economic stability. Another unique feature of this declaration was that it not only resisted the Western universal human rights in order to preserve their own cultural values, but also stated that the European Western values were fundamentally incompatible with Asian values which ought to receive priority. In the declaration and program of action which were adopted at the end of the World Conference on Human Rights at Vienna in 1993, one can see that the narrow cultural relatives position that was adopted at the Bangkok Conference was modified in favor of greater universality. In the recent years, the divide between cultural relatives and universalists has gone further to the extent that endorsement of one approach is seen as a rejection of the other approach. Strands of cultural relativism, universalism, and cultural relativism have several stands depending on their outlook towards human rights. Both concepts have radical approaches as well as moderate approaches. Radical universalism is extremely rigid in its approach and requires strict adherence to universally recognized human rights with little room for accommodating cultural diversity. It prescribes a rigid hierarchical order with regards to human rights. This theory is premised on complete denial of the idea of cultural sovereignty and self-determination. Such kind of approach needs to be rejected since there is no universal theory of moral absolutism regarding human rights that can find acceptance. Radical approach towards such issues seldom serves any purpose as it further increases the conflict between the two ideas. Radical relativism is another school of thought which needs to be avoided while contemplating a universally applicable regime of human rights. It's in our best interest to reject radical approaches so as to be able to strive for harmony and balance. Scholars have termed both these radical approaches to be misguided in the sense that they close the door for reconciliation. Essentially, there are two broad variants regarding the concept of cultural relativism, and the difference between the two lies in the strength of their opposition to universal approach to human rights. The distinction between variants of cultural relativism is premised on following grounds: substance of lists of human rights, form in which they are implemented, and interpretation of individual rights. Substance of lists of human rights. 1. The idea of human dignity is perceived differently in different cultures. Therefore, the exposition of a theory of human rights is bound to come up with a unique list of human rights. Human dignity is at the core of the notion of human rights, and human rights are viewed as an instrument to ensure dignity. If one particular culture has a different conception of human dignity, then it will inevitably have a different substance with regard to human rights. Second, form in which human rights are implemented. A theory of human rights may have a regime that may be rigid or flexible. The different levels of cultural relativism can be distinguished by the amount of deviation they allow from the universal values. The form in which human rights are implemented can vary depending upon whether one follows strong cultural relativism or weak cultural relativism. Number 3. Interpretation of individual rights. More often than not, the conflict between the two strands arises on the question of interpretation when the notion of individual rights has to be balanced against communal rights. At this moment, the validity of the particular human rights in question is seen to be viewed from the culture itself, and the difference arises with regard to the relative importance. On the basis of the above criterion, cultural relativism has following kinds regarding their conception of international human rights. Number 1. Strong cultural relativism / essentialism, cultural absolutism. The core belief of this strand of cultural relativism is that there are no absolute values or principles by which any culture or society can be judged apart from those of that culture itself. Strong cultural relativists believe that since an individual's moral conduct is defined and programmed by his or her culture, the issue is not a choice between universalism, measured by global or external standards, and cultural relativism, measured by local or internal standards, but between an individual's own standard vis-a-vis his or her communal culture. This strand of cultural relativism is a bit extreme in its approach, as it believes that endorsing an international regime of human rights amounts to complete surrender of cultural sovereignty. They believe that a universal applicable regime of human rights is not possible, since the conceptual foundations of any such framework can only be found in the Western thought. This school of thought also believes that if such values are mandatorily imposed on non-Western cultures, then it offends ideas like communal autonomy and the right to cultural self-determination. The essentialist framework has a clear view that there is no alignment between the Western and non-Western conceptions of human rights. Therefore, human rights cannot be made universally valid, since the rest of the world does not have any shared value with the Western value system. Now let's look at weak cultural relativism. This school of thought opposes universalism on two grounds. First, it argues that cultural sensitivities are of utmost importance for maintaining the check on excessive approach to universalism. It believes that certain culture is an important source of validity or moral rights. In this way, this variant of cultural relativism acknowledges the fact that certain aspects of universal theory of human rights are acceptable. This opposition is premised on the principle that all cultures deserve to be respected even though their philosophical foundations are located outside the Western school of thought. It calls for a contextual interpretation of human rights and abhors the practice of denigrating particular cultural practices. It aims at achieving universal consensus on the subject of human rights while taking into consideration the cultural diversity. Secondly, this school of thought differs from the universal framework on the notion of prioritization of civil and political rights. The concern of the relativists to this aspect of universalism is that such kind of prioritization undermines the significance of ESCR's economic, social and cultural rights as well as culture, which are critically important for non-Western and developing nations. In light of the above discussion, it can be seen that the major bone of contention between the relativists and the universalists is with regard to the impact of cultural diversity. The relativists believe that global cultures manifest so widely and diverse range of preferences, morality, motivations and evaluations that no conception of human rights can be said to be self-evident and recognized at all times and places without any kind of modification. The discourse around the conflicting worldviews of the two schools can be brought down to this conclusion. For every culture, some moral judgments are valid. No single moral judgment is universally valid. Perspectives on cultural relativism from different regions. What are the perspectives from different regions? In the previous section, the different theoretical perspectives with regard to human rights have been given to highlight the difference between cultural relativists and universalists. However, the cause of cultural relativism has been championed by different regional perspectives only. There is no single distinctive version of human rights in the world of cultural relativists, also since the emphasis is to have multiple frameworks of human rights. In this section, a brief overview of the major regional perspectives has been given. They have been covered in detail in the subsequent modules. Now let's look at one of the perspectives, Asian perspective. The most prominent proponent of the Asian perspective was Lee Kuan Yew, who believed that the Asian perspective could be seen as a countermodel to the Eurocentric approach of universalism. As per the Asian perspective, human rights cannot be viewed as a universally acceptable, applicable phenomenon, and they are rooted in the social, economic, cultural and political conditions of a particular region. Another major source of conflict for the Asian conception is that the fundamental unit of Asian societies is family and not the individual. There is a strong sense of nationalism as well in Asian nations. Therefore, the interests of the nation and family take precedence over the individual. Asian societies also give precedence to social and economic rights over individuals, civil and political rights. Second perspective is the Islamic perspective. The conservative factions of the Islamic world insist on maintaining the supremacy of religious doctrine with regard to the conception of their human rights. Islam as a religion also covers the political life of a believer. Hence, the theological perspective of human rights is uniquely defined in the Islamic world. Islamic perspective does not believe that individual rights are important means to achieve the ends of social justice. There has been an enormous revitalization in the cultural identity of the individual in the Islamic world due to the inflow of globalization. As per some scholars, Islam has granted the rights of freedom of thought and expression to all citizens of the Islamic State. However, on the condition that it should be used for the propagation of virtue and truth and not for spreading evil and wickedness. Similarly, Islam also gives right to freedom of conscience as well as conviction to an individual and has also given the right to the individual that his religious sentiments will be given due respect and nothing will be said or done which may encroach upon this right. Number third is the African perspective. The primary reason for this opposition from the African countries is because they could not participate in the development of the current international framework of human rights. For them, the universal framework does not have validity since they were not adequately represented in the meetings that defined those societies. Moreover, who do not have liberal and socialist worldviews that decisively shape the norms laid down. In its opposition to the universal approach, the African perspective joins the Asian perspective with regard to the hierarchical approach to human rights. Due to the reasons of economic underdevelopment, the African thought insists on social and economic rights. They do not object to the idea of civil and political rights, but they do insist that ECSRs need to take precedence over civil and political rights. Now the conclusion. Till now, the module has highlighted the differences between the two schools of thought, that is, cultural relativism and universalism. However, there is definitely room for harmonious coexistence between the two doctrines. The process of reconciliation can begin only with an acknowledgement that every culture has certain ideals or principles to contribute to the development and promotion of universal standards of human rights. The cultural relativists and universalists can find a common ground only when there is an agreement on a minimum standard of protection which has been conceived through cooperative approach. In the times to come, there is going to be a greater contestation between the concepts of cultural relativism and universalism. Through a balanced approach which takes into account all sides in the debate, it is indeed possible to resolve the conflicting views. However, there is one fundamental idea that needs to be protected during this phase of transition, that is, the concept of human rights itself does not become a casualty. It needs to be ensured that there is no scope of outright rejection of the idea of human rights altogether. In light of the above, it can be concluded that cultural relativism and universalism do have elements of commonality and should not be viewed as mutually exclusive. Once we start with the presumption of respecting human rights as a necessary and desirable ideal and cultures as a guiding force, the doors of reconciliation shall always be open. Thank you very much. The module concludes here.